Question: can the divorce papers I need to serve be served by mail, or do they need to be personally served? The answer to your question is yes. You can serve by mail, and Rule 4 of the Utah Rules of Civil Procedure provides for service of the summons and complaint by one of the following methods. Now, mail is one of them, but I want to cover them all. First, a party can waive formal service in writing, often known as a waiver and acceptance of service. Second, the summons and complaint may be served by the sheriff, the deputy sheriff, a constable or deputy constable, or by a United States Marshal or Marshal's deputy. It can also be served by any other person 18 years of age or older at the time of service who is not a party to the action and not a party's attorney. If the person to be served refuses to accept a copy of what's called the process, that's the documents that are being served. Service is deemed sufficient if the person serving the process states the name of what he was serving and offers to deliver a copy. Personal service is made by delivering a copy of the summons and complaint to the individual personally, or by leaving a copy at that individual's house, or what's also known as his usual place of abode, and with someone of suitable age and discretion who resides there, if not the actual person. You can also deliver a copy of the summons and complaint to an agent authorized by appointment or by law to receive service of process for that person. Personal service can be made upon an individual judicially declared to be of unsound mind or incapable of conducting the person's own affairs by delivering a copy of the summons and complaint to the person at the legal representative's office, if one has been appointed, and in the absence of such representative, to the individual, if any, who has care, custody, or control of that person. Personal service can be made upon an incarcerated person or a person committed at a facility operated by the state or any of its political subdivisions, like a mental hospital, by delivering a copy of the summons and the complaint to the person who has the care, custody, or control of the individual to be served, or to that person's designee, or to the guardian or conservator of the individual to be served if one has been appointed. Service by mail or by commercial courier service like FedEx is another way. That can be made and be complete upon the date the receipt is signed as provided by Rule 4. So what that means is you'd have to either do it by signing for a FedEx delivery or certified mail or registered mail. Fourth, service in a foreign country can be made by any internationally agreed means reasonably calculated to give notice. And such means would be authorized by the Hague Convention on the service abroad of judicial and extrajudicial documents, for example. If there is no internationally agreed means of service or applicable international agreement that allows for other means of service, then you can try that service reasonably calculated to give notice in the manner prescribed by law of the foreign country for service in that country in an action in any of its courts of general jurisdiction, or as directed by the foreign authority in response to a letter rogatory or letter of request, unless prohibited by law of the foreign country, by delivery to the individual personally of a copy of the summons and complaint, or by any form of mail requiring a signed receipt to be addressed and dispatched by the clerk of the court to the party to be served by other means not prohibited by international agreement as may be directed by the court. Man, am I glad we don't have to do a lot of international service. Additionally, where the identity or whereabouts of the person to be served are unknown and cannot be ascertained through reasonable diligence, or where there exists good cause to believe that the person to be served is avoiding service of process, the party seeking service of process can file a motion supported by affidavit requesting an order from the court allowing service by publication or by some other means. If the motion is granted, the court orders service of process by means reasonably calculated under all circumstances to apprise the party of the pendency of the action to the extent reasonably possible or practicable. Thank you for coming to Client School. I hope you learned a little more about service of process. I hope you understand that you can serve by mail and many other means are available to you for service. Thanks again.